Good afternoon and welcome to Legalized Negligence, where we discuss Florida's wrongful death statute, specifically Chapter 768.21, subsection 8, which hopefully there won't be a subsection 8 before long if things go well. Today, we are going to discuss Senator Yarborough's recent bill that he filed last week. Senate Bill 248. Right here, I'll pop it up on the screen in a minute. We've got Travis and I have gone over this, and we'd like to give our review of it. I have noticed that there is a lot of speculation about what it says and what it doesn't say, and what it does and doesn't do. And I've seen some people write some pretty nasty stuff about it and about Senator Yarborough, and we don't take that tack here at Legalized Negligence. We try to be level-headed. We try to think things through. We try to research instead of just flying off the handle and start threatening state senators. So I'm going to go ahead, Travis, and share that screen so that everybody can look at it and see what we're talking about. It'll take it a minute to pop up there. Let me know when you see it.
I do.
Okay, I'm going to scroll up to the top. This is a bill that Senator Yarborough has sponsored. I understand that Danny Burgess has signed on to it as well. And basically, it is changing the way that people are going to be able to recover damages in a med-mal claim. After reading it several times and researching some stuff and getting some clarification on it, the only problem that I have with this bill is that it still relies upon the administrative agencies of Florida, specifically ACA and the Department of Health, to find probable cause. Once probable cause is found, then we would be able to get into court to sue civilly for damages. Is that your understanding as well, Travis?
That's correct.
Okay.
That is.
When Travis and I were discussing this bill earlier today, I referred to this process as kind of like the Department of Health is giving us the permit that we need to then go back and get into civil court where we had been denied access to the court simply because we couldn't recover damages. So no attorney was going to take the case if there was no damages at the end of it. And to use an example that everybody is aware of would be our other person involved with us, Sabrina Davis. She's not with us this morning. But let's say that had this bill been law when her dad died back 3 years ago, she would have filed a claim with the Department of Health. Her complaint with the Department of Health actually made it all the way through the system, and they found the doctor negligent. And if it had been Sabrina, she would have been able to take the finding of the Department of Health that the doctor was negligent and then go to an attorney and get into civil court, where under current law, she couldn't do that. So I'm just going to go ahead.
Pre-suit requirement.
Say again?
That would have satisfied the pre-suit requirement.
Correct. And for those who don't understand the pre-suit language in Chapter 766, basically in a medical malpractice lawsuit, and let's say that the person even survives the malpractice. They didn't die from it because of it. They have certain requirements that they have to meet before they can ever even file the lawsuit. So this kind of like pulls us into that camp where we have certain pre-suit requirements that we have to meet, and those are going to be under the Department of Health or ACA. And then we would, if they find the doctor or hospital negligent, then that gives us the permission to be able to get into civil court. So overall, I think it's a good bill. I do want to be able to communicate with Senator Yarborough and help him understand that the Department of Health and ACA don't function as good as he thinks, as well as he thinks they do. There are some problems there, but at least this bill pointed that out, that he needs a little education in that area. So basically, the first part of this bill is it's the same language as that is in current law. So there's no sense in even reading all of this, because you can go to chapter 768.21 and read this exact same language. So I'm going to scroll down to where we get to the part that things start to change. For those of you who have never read proposed legislation, whenever you see, I hope you can see my cursor, whenever you see text that has an underline, it means that that's new language being added to existing legislation. Wherever you see something that has a strike through, that's where they're taking out a word or a phrase or a paragraph, and they will be adding different words in there. So like in this case, on line 36, it says injury or death, and it used to say that have become a charged against her. Now it's going to say which have become. So they correct the languages as they go. So I'm going to continue to scroll down until well, I was there. I didn't need to scroll anymore. Okay, this section here, starting at line 39, tells what what people are going to be able to sue for, and it describes who has standing, who's going to be able to sue, and it's going to be the personal representative of the estate is going to have standing to get into court. And then this is the part that I thought was really good, beginning on line 43, and I've got it highlighted here. It says any outstanding charges submitted to the descendant or the decedent's decedent or decedent's estate by a healthcare practitioner or healthcare facility found to have committed medical negligence that caused the decedent's death must be canceled by the court. In other words, if the hospital or the doctor starts sending you bills for things associated with the medical malpractice, the court must cancel those bills. So they can't, like they did in Sabrina's case, where they kept sending her bills and trying to attach the estate and her dad's property. They won't be able to do that anymore. So I thought that was good language. Travis, anytime you have something to add, please jump in here.
Well, it's important to point out that it's only that part affected as a result of the malpractice.
Correct. Which means, like in my mom's case, my mom was
bill.
Say again?
You can still get a bill from the hospital or the practitioners. This only wipes out portions of the bill related to the malpractice itself.
Yeah, like in my mom's case, my mom was in the hospital for 4 days before the incident took place. So they would be able to bill for whatever they did for her for those 4 days. But once she fell and was injured, anything that they did to treat that injury, they would not be able to bill for. They would have to eat that expense, which I think is very fair that was put in there. And then it goes on to explain what those charges are. Here on line 53, I've got some, well, on line 55, I've got some stuff highlighted. Let me read this section 8 here. The decedent's personal representative may initiate a medical negligence action to recover the damages described in subsection 3 for the adult children of the decedent, or the damages described in subsection 4 for each parent of the decedent, only as provided in this section. So you can see that they're already changing the law so that people who have not been able to recover are going to be able to recover damages.
Right, but let me point out that because it's the representative, you must be in probate.
That's right. And this is a good place for to pause for a minute and impress upon people that you need to have your paperwork, ready to go if you know that you're going into the hospital, or even if you don't. I mean, because you can wind up in the hospital from a car accident. These are documents that you need to have at home ready to go. And one of them is to have an estate or have a durable power of attorney or health care, or so that there is somebody and some documents in place so that you don't have to worry about it later. In our case, our mom died without a will, and we had to set up the estate after her death. So, you need to speak with an attorney, and we may be getting an estate attorney, to come do a podcast with us at some point to talk about how to get all those documents ready beforehand.
Yeah. Philip, we need to give our disclaimer that we are not attorneys. We are citizens giving our interpretation of the law or the bill. So do your own due diligence. We're not attorneys.
I thought people could figure that out just by the way we looked. I thought they'd look at me and go, well, that guy's not an attorney. No,
chance anymore.
Yeah,
you can't leave it to chance.
We're just two guys who read and study and research and try to stay on top of all of this because it's an important part of our life. So let me get down to how this Department of Health and ACA thing works, because there is some confusion about that amongst the various people involved in this. Basically, what this is saying, and I'm going to leave it up on the screen so you can read it, starting at line 62. Basically, what it is saying is that if somebody is injured through medical malpractice, and even if that injury leads to a death, you're going to have 180 days to file a complaint with either ACA or the Department of Health. And they're going to have up to 9 months to give a ruling on whether or not probable cause had been found. And I'll try to leave it up there long enough for people to read it, but then I want to scroll down to that actual section. Once the Department of Health or ACA finds that there is enough probable cause to bring either the doctor or nurse or the hospital before a board, and they were found negligent, then that's kind of like our ticket to be able to go to an attorney. And now that there will be damages available for recovery, the attorneys will be able to make a decision about taking the case. But even under current law, an attorney still has to look at the facts of the case to decide whether or not it is worth his effort to file a lawsuit. If he thinks that the injury was only going to be worth like $5,000 or $10,000, he may say, my time is going to cost more than that. We might be able to recover damages, but it won't even cover my expenses. So you need to decide if you want to, if you want to bring a claim or not. So we're facing the exact same thing that anybody else would. You still have to prove medical malpractice in court. All this legislation does is makes it where the Department of Health or ACA is the one to determine whether or not malpractice has occurred. And if so, then we're able to get into the civil courts to pursue damages. Those two agencies will still deal with the medical licensee or the hospital and whatever sanctions they want to place against him up to pulling his license. But we
need to understand is this is not a 51% determination. This is still like a 75% finding on part of DOH or ACA that that there's a reason to find fault. So
Yeah.
we as citizens still at a disadvantage the way it's currently written.
Yeah, but so that people understand the other side of that. I mean, try to put yourself in the doctor's shoes for a minute, and I think it's fair to do that. Just because somebody believes the doctor committed medical malpractice, that still has to be proven. You know, the allegation alone does not mean that malpractice absolutely occurred. And if I was the doctor, you know, I would want a higher level of review or proof before they pull my livelihood away from me. You know, I don't see anything wrong with that. It happens in the criminal courts all the time. There's a higher burden of proof in the criminal courts than there are in the civil courts. Civil courts are 51%. Criminal courts are 75 and above. So I don't really see anything out of the ordinary there.
Well,
Um,
I could see going after his license, affecting his livelihood, having that higher preponderance of proof. But in terms of taking care of the estate and recovery of expenses and such, um, I think the people still need to be fairly represented at that 51% level for some recovery, not necessarily affecting his license and livelihood, though.
Right. And you and I discussed that earlier this morning, where this is our opportunity. We have, you know, like 2.5 months that we can talk with Senator Yarborough and get him to understand that. I don't know if he does or not, but we certainly need to bring it to his attention that, you know, maybe something along the lines of, as the Department of Health is reviewing the case, if they reach the 51% level, maybe it can then be kicked back where we can get into civil court. And then they have to decide at the 75% level what they're going to do with his license. But I can't stress enough, even though we can get into civil court, you still have to prove medical malpractice to a jury. You know, just because you got to the court, and this will address this in a minute, you can't use the Department of Health's finding as evidence. You know, in other words, you can't take their finding and say, I won the case. All it does is allow you to go after damages now.
It only settles the pre-suit requirement. That's all it does. That's all it gives you.
Correct. Let me see. Okay, this is just talking more about. I'm trying to get down to the part that we've all been waiting for, and that is uh,
The revocation of subsection 8.
that's exactly right. I'm just reading. Okay. Well, I tell you what, I'm just going to scroll down to that because that's the part everybody likes that we've all been wanting. Okay, if you read this section here, this is subsection 8. I'm going to share a different screen for just a minute so everyone can see what I'm talking about. Hang on, stop share, subsection 8, share. Okay, it's loading. It'll be there in just a minute. Come on, come on, come on. Okay. Has it shown up yet, Travis?
It is. It's wide. Yeah, it's up.
Okay. Sorry. Do you think that has something to do with the monitor I use? What?
Yes, it does.
Is it? Okay. But can you read the whole thing?
I can. People on smaller devices wouldn't be able to, but I can read it.
Okay. Well, if you look down at the bottom of this under 8, that's subsection 8 that you always hear us talking about. Damages specified in subsection 3 shall not be recoverable by adult children, and the damages specified in subsection 4 shall not be recoverable by parents of the adult child with respect to the claims for medical negligence as defined in chapter 766. That's the part that has always kept us out of court. Now I'm going to go back to the legislation that Senator Yarborough is proposing, and we will look at the wording there. And you can see as soon as it loads, good time to take a little sip of Mountain Dew. Okay, you can see where that has a strike through. That is exactly the wording of that statute, of the current statute that I showed you. In other words, they have removed subsection 8. Now I'm going to go up and talk about the last line of his of his bill, which was a little bit confusing when we first read it, because it sounded like what it did was nullify everything above it. So what line 102 says is a finding of probable cause by a probable cause panel or the department, meaning the Department of Health, is not admissible in a medical negligence action authorized under this subsection. So we thought there was some legal wording there that kind of like nullified everything that we thought they had given to us. So we reached out and got some clarification. I'm not allowed to say where that clarification came from at the moment, but I will in the future. That clarification says this, and you can read along with me here. The language on lines 102 through 104 is for clarification of usual practice in court. Admission of the panel's findings would be considered unfairly prejudicial. A court would not allow that to be presented to a jury. A finding of probable cause is a preliminary finding by the panel without a full adversarial hearing. A full hearing would be held by the Division of Administrative Hearings, and both sides would be allowed to present evidence, call witnesses, etc. What that means is if the Department of Health determines that the doctor was negligent, you can't take that finding and use it as your evidence of negligence in a civil court. All it does is allows the attorney that you're going to hire to realize that he can now sue for damages. So you still have to go through the same thing in a civil court and convince a jury that the doctor was negligent. You can't use the Department of Health's finding or ACA's findings to win your case in court. Did you have anything to say about that, Travis? Because I know we discussed that quite a bit.
Yes, the way the bill's currently written, this means that in DOH and ACA, they have to surpass or reach a 75% finding of fault before the people can then go after a 51% finding of fault. And, during our discussion, I equated that to the O.J. Simpson trial, where the state did not prove O.J. Simpson was at fault, but the family, separate from that finding, was still able in civil court to have their finding found. And we are hamstrung in that we're still tied behind the finding of DOH and ACA. And that's my personal gripe with this bill, the way it's written, is you have to surpass and get to 75% just to come back down and recover at 51%. And I wish that would be corrected in an amendment.
Yeah, and it may be. I mean, like I said a minute ago, now that we've gone through this and we have narrowed it down to this one issue of the fact, the fact that they're leaving it up to the Department of Health and ACA to make the determination. And since they're administrative agencies, they don't function the same way as a civil court. So we have 2.5 months to address our concern about this with Senator Yarborough and see if he's willing to work with us on that. I tell you, I just I just really don't see a whole lot wrong with this bill. It bothers me that it's still the Department of Health that gets to make that determination, but if we have to prove it in civil court, we have to prove it there too. I just don't like the way that the Department of Health handles these cases. We don't get to rebut witnesses. We don't get to see anything that's done or said. Once we give our side of the story to the Department of Health, they reach out to the other party, they get their side of the story, and it's not the same interaction that you would get in a civil court. That bothers me. And I would like to see that change, but I don't like administrative agencies at all anywhere in government. I don't think number one, I don't think they're constitutional. Number two, I think they have taken away the people's expectation of equal branches of government. So that's why it bothers me.
The other thing we had spoken about was, can we use the work product, the investigative product, in civil court as opposed to just the final finding report?
Yeah, and right now, until we can speak to Senator Yarborough, we can only speculate on that. And my speculation would be, once it becomes public, we can certainly look at what they did. Right now, when they close a case and did not find probable cause, the records are sealed, so we never know what happened. But in those instances, like in Sabrina's case, where they found probable cause, she can request those records and find out exactly what happened. So that's something to talk to him. I think it still has to be fine tuned a little bit, but overall, they struck subsection 8, which we wanted them to do. They've made it where if we get a finding of probable cause through the Department of Health or ACA, then we can go back to the civil court and sue for damages. I think they really put some effort into trying to achieve what we've been asking them to do.
Yeah, it's not 100%, but it's progress.
Yeah, and I don't think it's just a little progress. I see where they've added one hurdle that if you were on the other side of this, you would probably want that hurdle there, and that's not bad. If somebody was accusing me of something that was going to destroy my livelihood, I would want them to pass a pretty high bar to be able to take away my livelihood.
Well, and that bar previously was subsection A, so we take one hurdle down, we get another, but I understand it. It just, in all fairness, I feel that there should be a 51% finding as well as a 75% finding by the board.
Well, let's talk about that just a minute. Maybe it'll spur some thought in other people. Let's say that there wasn't a department. Well, no, you can't do that. Let's say that subsection 8 did not exist before, all right? And we were able to get into civil court. Anybody could be able to get into civil court. If the doctor was determined in civil court to have committed malpractice, that jury is not going to deal with his license. It's still going to be punted to the Department of Health to deal with the license issue. So now
the three strikes rule exists, and it would count as one strike. So I would say, let's give up the 3 strikes rule, because it never came into play with subsection 8 in. We never got into court in order to get a strike. So I'd give that up and let DOH solely deal with the license aspect in order for us to gain that 51% just for the damages aspect, not affecting the license. Right. I think that's fair because we're civil court. We're not dealing with his license. That's DOH and ACA. Well, not ACA, but DOH. Let them deal with the license at their higher preponderance of proof, 75%. Let us deal with the damages at the 51% in civil court.
Yeah, and that's an issue that we can bring up to Senator Yarborough and see what if we can persuade him to see that, then maybe he'll go in and tweak this a little bit, because right now it's just a bill. They're not even in session. So it's just a bill, and it's got to be heard. It's got to go through committee. There's a lot of discussion that has to go on about it. But I think for a first stab at it in the Senate, I think this is pretty darn good.
I agree. I agree. Yeah, I think the work needs to be done with education on the aspects of Department of Health and the makeup of the board, and because that's ridiculous, to have so many people against the citizens. It's like they're all doctors or related to the medical field in one way for the benefit of hospitals and doctors. There's not really people like you and I on that board looking out for us.
Yeah,
and I don't think Barbaro understands that.
Yeah, that's the part I'm not sure. Maybe he does, but I would like to ask him that question and see, ask him, do you really understand how this works? Because when the legislature created the administrative agency, basically they just gave them an instruction: license doctors and nurses and regulate them. And then the legislature went on to do other things. And that's true with all administrative agencies. They're just given a task and then left on their own to do it. And on occasion, it needs to be pointed out to the legislature that they're not achieving the task that you've assigned to them. Let me tell you why. And then the legislature can get back involved in it and, kind of straighten them out and get them to do it the way that they should be doing it. I'm going to walk through just very briefly what happens when you file a complaint with the Department of Health, because I went through that on my mom's case. You make a complaint. You have an investigator is assigned to your complaint. They get in touch with you and they get your evidence. In other words, they ask you, okay, what happened? And you tell them your side of what happened. They take that and then they reach out to the party that you're accusing of negligence. And they say, there has been a complaint filed against you. Here is the complaint. What do you have to say about it? And then that side gives their story. So the investigator compiles that information, puts it into a report. And if he or she thinks that there is enough evidence there, it will be moved up the ladder to what's called a prosecution unit. And that prosecution unit is attorneys, and they will look at the evidence that the investigator pulled together. And think of it in terms of a police officer who takes a report. He gets a report from both sides. He gets information from both sides, writes a report, and then he takes it to the DA. That's kind of what's happening here. So this prosecution panel looks at it to determine, is there enough evidence that the probable cause panel should review this to make that determination? In my case, it was. It made it through the investigation, it made it through the prosecution unit, and it made it all the way up to the probable cause panel. When the probable cause panel reviewed it, they closed the case because they said there was not enough. It didn't reach, the 75% level to say that there was enough probable cause. Of course, I disagreed with that. So I filed an appeal and they denied my appeal. But those are the things that Senator Yarborough needs to know about. He needs to understand that they're not really looking out for the people. And that troubles me, because the same agency that licenses doctors and nurses is the agency that corrects them when they do wrong. So if they're correcting a bunch of doctors and nurses by sanctions, that's saying that they're not doing a very good job when they give them a license. It's like having the fox watch the hen house. The same group of people is doing both jobs, and I think that those should be separate. And in the civil world, they are separate. It's not separated in the administrative agencies.
They not only have to find fault with the licensee, but they're admitting to finding fault with themselves because they allowed the licensee to perpetrate the malfeasance.
Yeah, and Travis,
the event.
why don't you go ahead and explain a little bit about the board itself? It makes it all the way through investigation, prosecution unit, probable cause panel, and it makes it up to the board of either medicine or nursing. And these are the people who are going to make the determination about what happens to that negligent doctor or nurse. Tell me who that board is.
Well, the board is comprised of 15 people. I'm talking about the medical board here. 12 of which are doctors. 3 of them are citizens. 1 of them must be a hospital risk management manager personnel. So they're advocating obviously for the hospital. The other 2 citizens typically end up being attorneys who work for law firms that defend medical practitioners and facilities, hospitals. So everybody on that board is against the people in theory, technically, statistically. But if you read some of the language of the administrative court, as few as 2 people can make up a board, one of them not being a current board member, but a past board member. So there's really not a lot of representation when you cut it down from 12 down to 2, and you have to have a majority. Well, how do you get a majority with 2? So by default, they're found not at fault if just one of them finds them at fault. So a lot of the administrative court goes against the people just out of the way it's written. And there's a lot of room for improvement, and we're going to bring it to light.
And another fault that I find with the Department of Health, an administrative agency, is that once you give your evidence to the investigator, they take it out of your hands. You don't get to do anything else anymore. Now, compare that to a civil court. You bring your evidence to an attorney, and your attorney calls witnesses. You get to cross-examine witnesses. You get to rebut witness statements. You get to determine whether or not the witness is credible. I mean, there's a whole lot that we get in a civil court that we don't get in an administrative court. And that's why I think there's a lot of unfairness there, and what we want to point out to Senator Yarborough. I think that his heart was in this. I think he was truly trying to give us what we were looking for. I'm just not sure that he totally understands what the administrative agency does in reality. On paper, right, but in reality, I don't think he does. So what you were telling me a minute ago about who comprises this board, it sounds to me like what you're saying is, if I got a traffic ticket and I wanted to fight it in court, and I go to court and the jury of my peers is 12 police officers. Basically, that's what you're saying, right?
Correct. 12 police officers, but they're going to add on the police dispatcher. That would be the equivalent of the risk management personnel. Yeah. And basically, they're all going to be against you. You don't have a chance. You really don't. And again, it's not 51%, it's 75%.
Yeah. So, I think it's I think it's worth just staying cool-headed about this thing. If any of what we've said helps you understand this bill a little bit better, great. I encourage you to read it on your own, to reach out to Senator Yarborough's office and have some clarifications made. It's easy to find on the internet. It's just, type in Florida statute, or SB 248, and you can pull up the language of this bill and, read it, ask questions, call Senator Yarborough's office and say, look, this is sounding pretty good, or this is sounding pretty bad, and can you help me understand portions of it that I don't. The last thing you want to do is start threatening. Don't start yelling. Don't start, well, I'm going to do this and I'm going to let everybody know. And, start copying the governor and the governor's wife and, just losing your mind about it. These are the people who have the power to make the change that we want to see made. So why alienate them? Why be nasty to them? My mom used to say you'll attract more flies with honey than you will with vinegar. So be nice to them, let them see that you want to engage, and they'll be helpful back. And we will eventually get what we're trying to achieve here.
Here's another thing about the bill we haven't discussed yet. There's a default that if DOH takes a certain amount of time to complete the investigation, it defaults to a finding of a fault.
Yeah,
not that word.
I scrolled right past that. Here, let me go. I just pulled it up on the screen. If you start reading it, line 98, we're talking about healthcare administration or Department of Health, and there has not been a dismissal or final resolution of the complaint within 9 months after submission of the complaint. The determination of probable cause is deemed to have been made. So if the Department of Health drags their feet or ACA drags its feet and they don't finish up their investigation and come to a final resolution within 9 months, it automatically defaults to where there's negligence. Now you can go to court.
You get that pre-suit requirement ticket and you can go to court.
Yeah, I think
180 days right above that on line 96.
Yeah,
you have to file your complaint within 180 days. So you really have to dig in and to the medical record and know what your complaint is about. Of course, that means you have to have the records. So you file your HIPAA request for the records. They got 30 days to respond. They can respond by asking for more time, and all that into your 180 days. So you really got to be on the ball. I see that as a caveat that we have to overcome, maybe get an extension of that time. But at the same time, because damages are now allowed, you have the help of an attorney who could possibly put more eyes on the medical record when you get it to find the fault. And that's a benefit to us.
If I would have known in my mom's case that we had to have a personal representative, we had to have an estate and a personal representative, we could have gotten the medical records very quickly. Where they drug their feet is they kept saying, well, you need to have we can only release these medical records to the personal representative of the estate. So they kind of drug us along for like 60 days or something. But this is why I'm saying that people need to have, just like anything else, you keep a blanket in the trunk of your car and some jumper cables and some water, because things can go bad sometimes. You need to have your paperwork together too. You need to have a will done. You need to have somebody assigned to take care of this or take care of that. And this is just the world that we live in. So I think it's smart to have all of this stuff. I've learned a lot over the last 3.5 years about how to prepare, because this could be something that you run into at some point in your life. But, I would just encourage people to read and to reach out to Senator Yarborough and thank. Hey, Travis.
I see you.
I guess we dropped
recording.
Yeah, the recording is still in progress, so we'll just kind of close out here. I don't know that there was really anything else to say unless you had something you wanted to add.
Well, just that the probate will take time to set up of that 180 days also. So there is a lot going against us there with that time limit.
Yeah, and that's why I mentioned that I would like to have an attorney, a probate attorney, sit with us in a podcast sometime and tell us what we might do in preparation for that. There may be a document that we can have prepared and ready to go that makes it where we don't have to wait. I don't know. I'd like to ask an attorney if that's a possibility. So stick with us, and we'll continue to bring you information on all of this. And the biggest thing is just don't be mean to these lawmakers. We're trying to get them to work with us to achieve a goal that we want to achieve, and don't be nasty to them. All right, Travis, you have a good day.
Thank you too. Take care.